Dear students, today we can solve a problem under administrative law regarding the bias which will comes under the concept of natural justice. Here, more or less, in every question paper of administrative law, this sort of the problem with regard to the bias. It may be pecuniary bias, it may be personal bias, it may be official bias, or bias as to subject matter. One problem may be given. It is the rest assured. Here, today, we can take up the problem concerning to the personal bias. Here, the problem is that here one senior officer is there. He has praised the junior officer in the confidential report. That means there some CR report has to be given by the senior officer. In every government department, there will be some confidential report will be there. And here also, one senior officer, what he has done, he has given the favorable, appreciable report with regard to the junior officer. It is quite common. But what is the specialty of this aspect is that, this case is that, here there was one promotion committee has been formed. So thereby this senior officer happens to be the member of that promotion committee. And naturally, he has recommended the name of his junior officer for the promotion, excluding other members. He has not considered the other members. And one of the member, he has challenged the promotion of this junior officer, where this senior officer has appraised his junior officer in the CR report, that is confidential report. Here the problem has been given whether such the person who is called as N will he succeed? Can he will be succeed? So that is the problem. Here we have to solve this problem according to issue, rule, analysis, conclusion. That means easily we can solve. If we adopt this method, easily we can find the solution. Here as I told you, this will come under the principles of natural justice, and when any problem has been given, we have to frame the issue. So how issues will be framed? Here I used to tell in my all the videos, framing the issues is the art. Normally it will be some difficulty will be there, but when you calculate, when you start practicing framing the issues, it will be very nice. Even when you become the advocates, you should have to frame the issues, and the court may analyze the issue framed by you, and in turn the respondent advocates and plaintiff's advocate, when they give the issue, the court will finalize the issue. So here there being what is the issue here means whether such the promotion is valid one, where the promotion committee member, he happens to be the senior officer or person of the person who has been promoted, and where he has given the favorable confidential report. That means here he has shown his mind that such person is fit to be promoted in his CR report. But here what is the yardstick? What is the test to annul the promotion? That means normally we cannot question it. There will be some test will be practiced. So what is the test has to be followed? That means here the test is that here there should be prima facie. It should give to the reasonable apprehension of bias. Here such promotion should prima facie show that should give room for the reasonable apprehension of bias. Here what we have to see, there should be the bias or conflict of interest, that has to be proved. How far with regard to the person who has given the favorable report and who happens to select the person sitting in the promotion committee. So this aspect we have to see. That means it is related to the principle of nemo judex in causa sua. That means no one should be a judge in his own cause. That is the principle adopted with regard to the what you call the personal bias. Now I think you understood what is the problem. The problem, I am not going to repeat it. Here, when you got the problem in this question paper, you have to frame the issue and you have to highlight the provision of law or rule of law. Here, the provision of law, that will come under the personal bias. This you have to write. And what is the principle has to be adopted, that you have to write. That is the things. And here, if you happen to write the what you call case laws also you can write, or otherwise you can discuss in the part of analysis. In analysis, you have to carefully discuss all these aspects, that is the issue, provision of law, rule of law, with the support of the what you call legal principles and the relevant case laws. Here also, I have taken certain case laws, that is A.K. Kripak versus Union of India. Here, more or less the facts of the case is more or less same, but little difference is there. That means one of the person, he has applied for the job under Indian Forest Service. IFS, he has applied for the job. But what happens? He was himself is a candidate, and he being the candidate, and he is the member of the selection board where they are going to select the candidate for the Indian Forest Service. That means in other words, what I want to put you that here a person is a member of the selection board, and being a member of the selection board, he has applied for the job of IFS, and he has being a candidate, and in the selection committee, even though he has not participated, his name has been recommended by the other members of the committee of the selection board. And here this aspect has been questioned. So this has been said as that is the likelihood of bias or the personal bias. That has meant that other members of the selection board normally they will prefer that their fellow members would be selected. That is the common thing. So it has been questioned. So there the Supreme Court has held that it is a violation of the principle of natural justice. Likewise, in Maneka Gandhi also, Maneka Gandhi versus Union of India, some principle of law has been upheld. Here, the facts of the case is different from the facts of the case which has been given here, but we have to adopt the principles. Certain times what happens when you become the advocates, you have to cite so many case laws, and certain case laws may be similar to the what you call facts of the case, what you are referring, and certain times it may be different. So there what you have to know that you have to adopt the principles. Certain times you have to adopt only the principles. Here also we have to adopt the principles upheld in the Maneka Gandhi versus Union of India. Here the Supreme Court of India has said that with regard to the principles of natural justice. That means the principles of natural justice means it is a fair play of action. And this doctrine of natural justice seeks not only to secure the justice but also to prevent the miscarriage of justice. So here what we have to understand, it is this natural justice, the main aim of the natural justice, not only to secure the justice and also to prevent the miscarriage of justice. That means to say there should be procedural fairness should be there. There should be absence of bias should be there. Bias should not be practiced. So that means there should be fair procedure should be there. There was some saying is that Caesar's wife is above suspicion. That means it seems to be very funny, but this sort of the what you call proverb will normally used in the administrative law. That means the action should be very much fair. That wants to put it in such a way. Okay, there are other case laws are there. Ranjit Thakur versus Union of India. Here one army officer was punished by his senior, on the ground of his personal enmity. That is personal bias. Same thing, bias was evident there, and there is the test is that whether the person was actually biased or not, based on the reasonable apprehension of bias. That means what is the yardstick? How to analyze the test? Means there should be what you call on the face of the facts of the case. There should be evident that the bias has been practiced. That means that will give grounds to the reasonable apprehension of bias. Likewise, in Ashok Kumar Yadav versus State of Haryana also, same facts of the case what we have taken here. That is, selection committee members were close to some candidate. That means your selection committee members were close to the candidates who has appeared for the what you call some job. So normally what happens, there is a likelihood of bias will be there. Such time, at that time, there will not be fair procedure will not be there. Fair selection will not be there. That is that will be bias will be practiced. So that will give room for the administrative discretion, which is against to the administrative law principles. Probably you know what is Dicey's rule of law, which are all the things we have come across under the Dicey's rule of law. That is the Dicey's rule of law, which will cater to the needs of the what you call the people. That is predominance of the legal spirit, equality, and the prominence should be given to the law. Likewise, there are certain things will be there. That means whether it may be anybody, it may be what you call a senior officer or junior officer, they have to care for the principles of the natural justice. So if they don't follow the principles of natural justice in their administrative discretion, at that time it is a failure of the principles of the administrative law. So at that time, what will happen? Such selection will be doubtful. That means such selection will be doubtful with regard to the which is against to the fair selection or fair procedure has been adopted. So in this case, what is the thing we can see that here N is likely to succeed. That means he can challenge the promotion. He can challenge the promotion with regard to the person who has been selected, who has been promoted, not selected, who has been promoted. With regard to the person who has shown his senior officer has shown the personal bias. So in this way, you have to solve the problem with the help of the IRAC method. So in our future classes, we can solve as much as problems as possible. So this is with regard to this video.